Yes, welcome to the No State Project live from the fortified compound in Mesa, Arizona. Glad to be back with you here. Good to be live again. It's episode 98 of the big show. So I appreciate everyone tuning in for that. I do have to thank everybody who did or who continue to support the show. Is very, very much appreciated. So if you'd like to help support the show, well, maybe this is for the podcast, but you can do so at markstevens.net. That's markstevens.net. A lot of stuff I want to get to today. I got to do this before the callers start to roll in, and so I do have to beg the indulgence of the callers because some things just got to talk about. There's been a few very consistent vocal critics that. And it's a considerable lie that they have that all I discuss are the success stories, and I post those, but I never discuss train wrecks, which isn't actually true. In fact, if you go back and listen to the shows and see videos, I've spent extensive time on some of the worst train wrecks and the worst situations that people have gone through. Then that far exceeds the amount of time that I talk about success stories. So, just not true. And so we have two success stories to post that I'll get there this week. And a third where Home Bumming may call in, where it's a situation where, he was able to do some damage control, where he got a smoking deal, on his own, without a lawyer. So the idea that you have to hire a lawyer, and I'll say for things short of, really serious felonies like murder and rape, stuff like that, you don't need a lawyer, especially for these code violations, misdemeanor code violations. No, it's ridiculous to think that you have to hire a lawyer, even if you're just planning on making a deal. You can get some leverage on the prosecution by showing that their witnesses are not qualified, that they're making arguments that they can't possibly prove, that all they can do is say, I don't have to prove that. The judges won't let me, okay? So, keep that in mind. So, that you don't need a lawyer. You don't have to spend hundreds or even thousands of dollars on a lawyer, even if you're just trying to make a deal and you want it to go away. You don't need to get a lawyer to do that. And Home Bumming will call in and give us a report on just how good of a deal he was able to get. Pretty certain there was no jail time, and so kudos on him, because sometimes that's all we're trying to do is limit the damage that these criminals are trying to do to us, and sometimes it's the best we're going to be able to do under the circumstances, especially the stress of having to deal with these people. Sometimes that making a deal like that is to make it go away is sometimes the best we're able to do. So. I will provide details in a separate video regarding the other success stories. Two were full, they were just thrown out, which is really great. I like the judge one saying, well, I can see that he's looking at the motion to dismiss. I'll give you this detail. He said, I'm looking at this motion to dismiss, and I can see that this is going to take, the trial like this is going to take an awful long time. So I'm just going to go ahead and dismiss it now. Yes, because that's what judges are in the habit of doing. They just look at it and say, oh, I think this is going to take too long. We're going to kick this out. Yeah, because prosecutors aren't going to appeal that. Prosecutors aren't going to be absolutely outraged that their little complaint has been tossed out because the judge, not for any legitimate due process concerns, I don't think this is just going to take too long. Hey, we'll take it. But I want to talk about some train wrecks here. I'm still going to this is the thing. I'm doing this not for the critics. I'm doing this for people who may want to defend themselves so that you have more context so you know what you're getting yourselves into. I am dead serious when I say that these courts and the government is just men and women who force strangers to give the money and that they're a criminal organization. And I just laid out the facts as to why they are a criminal organization. When you force strangers to give you money, whatever the pretense may be, when you force a stranger to give you money, you are a crook. you are a con man, criminal. And so those are the supporting facts. And no, I'm not using that as a dodge or, well, that's so I'm not telling people that there's any magic, bullet here. There's no silver bullet. We're going against crooks. We can be successful. We are successful. We have a lot of success stories, but there's also train wrecks. I call them that because, and those are common. We're dealing with crooks. We're dealing with people who don't like to be questioned. Okay? An idea of how they operate, just go into markstevens.net and listen to some of the call and shames. I'm not making it up. Oh, I'll get to something the critics made up. I'll get to that soon. But, okay, so we're doing all right. But, it's not my way of saying, well, just because, you weren't able to get your ticket thrown out. No, because they're criminals. That's my way out of not looking like a con artist. But I've been upfront with that from the very beginning. Adventures in Legal Land was in 2003. It was years before. I mean, I wasn't even providing a lot of stuff that I do now on the website. So, no, it's not a way for me to, in my escape clause, some plausible deniability. Well, you are dealing, you know that going into it. I don't say that. I'm not sitting here and saying, oh, if you do this and that and you do the Democratic method, you're going to get it tossed out. And then if it doesn't get tossed out, well, they're criminals. I should have mentioned, you're dealing with crooks. Of course, you can't, but they don't like being questioned. So one of the videos that's really good that should really, well, my humble opinion, I think should have, 100 times more views than it does, is Colby Granville. I had a great hairdo at the time. Well, they used to call us Cool Breeze back in the day. I still don't know why that was a pejorative, but Cool Breeze. Anybody has an explanation why Cool Breeze, if you're in the military, why Cool Breeze is a pejorative and an insult? Let me know, because I still to this day have no idea. Anyway, I was Cool Breeze at the time, and he was very honest in their assertion of jurisdiction. He was a sitting city councilman in Tempe, Arizona, and he was very honest. And it's on HD video. It's very clear for everyone to hear. We have jurisdiction because we said so. Okay. Oh, proof by assertion. Okay. Oh, and because they put other people in prison, which is the official position of the Maricopa County Attorney's Office. And also by confirmed by Scott Bales, who is the Chief Justice of the Arizona Supreme Court. So we know they don't like to be questioned. In fact, another one in Scottsdale, you listen to the police chief that I spoke to, Alan Rodbell in Scottsdale, and he hangs up the phone in anger because he went months not wanting to do a short interview with me, and you get his attitude and his why he didn't want to speak to me, because he's a part of a criminal organization and he can't possibly defend it with a logical, coherent argument, which is why you have people on YouTube and whatnot, Facebook, that they'll say, oh, the laws apply because the judge said so. But I'll get to that. So we have two train wrecks in particular. I'm not going to bore you with all the details because it's a lot of the same thing. Someone right here in Phoenix, and she went into the court, and she had the motion to dismiss, and she had the discovery request, and she started asking the judge some questions regarding the prosecution's burden. Had the prosecution and submitted sufficient facts to overcome the motion? Well, the judge, according to her, is irate, like instantly, just raging. And he snaps at her. He is not going to allow her to take control of his court. So asking questions regarding the prosecution's burden of proof on a pending motion, a motion that's in play, hasn't been ruled on yet. They're there, and it's supposed to be ruled on. I think due process does require that much. Pretrial motions be, ruled on and disposed of, prior to trial. It's in the friggin' name, pretrial motion. So, no, it's Cool Breeze, long-haired people whose hair blows in the breeze. Now, we were all bald at the time. So I don't think that that's right, Steve. This was in the military when we all had shaved heads. So they didn't call us boot. Well, I guess that's only for a Marine. But, no, I don't think that that's doing it. How that's a pejorative, I don't really get. But, anyway, okay. So, the judge is automatically, right off the bat, trying to conflate someone defending themselves with taking over the court. No, this is just a somebody, because look, this is an emotional reaction by somebody who does not have adult coping skills. I've said this 1,000 times. People with adult coping skills do not start raging at somebody because they asked a question. Even if you take the position that she shouldn't have been asking questions, you're one of these people who think that only lawyers get to ask questions, or asking questions is not a way to adequately defend yourself besides the mountain of evidence to the contrary. You don't start raging at somebody. You don't get irate and start yelling. It's not like, that's not how adults are, behave. People who have their emotional coping skills stunted at 5 or 6 years old, children, they respond, by screaming and yelling because they're not getting their way. Oh no, somebody I forced to come in here who, under threat, duress, and coercion, I'm threatening them with jail if they don't participate in this, and they had the audacity to ask a question. Oh, what do I do in such a situation? Oh, because other people may see a non-lawyer asking questions and start to get ideas. How can you possibly run a criminal organization by allowing the people you forced to come into that room to go through this dog and pony show called a trial, if you're going to allow them to start questioning things? Okay? This is religious fanaticism. All right? Where the idea that you should not be asking questions. You know my response to that. It had its intended purpose and objective met. When you've got a judge that starts yelling at you and is furious, again, just asking a question, it has a very, very chilling effect. Okay? It's intimidating. It's called bullying. And I don't think that bullying a litigant is consistent with due process. Again, people will argue with you and, yeah, but you're not supposed to be asking questions. That's not true. I've seen very seasoned attorneys asking questions. Very good attorneys. You can look it up. It's all over YouTube. This stuff is not new. They just don't like the type of questions that we're asking. How dare you challenge the very foundation of these sacred proceedings? Oh, I know. I have one simple solution. I'm going to yell and scream at you and intimidate you and get you off point, and then you're going to be too afraid to defend yourself. Because if the judge has been irate and is yelling at you about asking questions, just how are you going to feel when you go to cross-examine the cop? Okay? Especially after every single one of your objections has been denied without question. No ifs, ands, or buts about it. Okay? Very intimidating. So she is going to have to appeal this. And I think one of the bigger is the fact, and yeah, I would argue this. I was bullied. The judge bullied me. The judge threatened me. He yelled at me. And did everything he could short of actually arresting me to intimidate me from defending myself. So, another one where, so the judge just denied the motion, no explanation at all. Wouldn't answer any questions regarding the record and what evidence he was basing that on. That's not asking for legal advice either. Asking what proof the judge's determination is based on is not asking for legal advice. No. For my hearing and no. And we had a demur this week that was also denied. without explanation. We also had a situation where they were raising the issue of the corpus delicti, that an element of the charge had not been even alleged. And the judge snapped and stated, you are raising issues for civil law and has no application in a misdemeanor case. Far as I know, misdemeanor, criminal, corpus delicti applies. Yes, I know it has to do also the corpus delicti rule. But they can't, this is that they have to have physical evidence in addition to a confession. I know. But the corpus delicti is described as the act and the result. That's the body of the crime. There's the corpus delicti, there's corpus delicti rule. So if there is no confession, the corpus delicti rule is not applicable. But that doesn't mean they're not supposed to have the body of the crime, the actual act and the result, because it's an adversary proceeding. And adversary proceedings require an act and a result of the violation of a legal right and damage. Looking at, I'll maybe if I post a good video, I'll have in the the graphics where you can see in Arizona they use act and result. So they use. So those are some examples of the train wrecks that have happened just in the last few weeks. I don't want anyone thinking that it's easy to defend yourself in court. It's not. You can have a slam dunk open and shut. The facts are completely in your favor. It's going to be still going to be difficult. This is no cakewalk. And anyone says that it's easy to win in court, even Jerry Spence, who's undefeated in criminal cases, is certainly not going to say it was easy. It's tough. It's intimidating. You've got a 5-year-old on the bench with a robe on who is absolutely immune for whatever they do to you. They can falsely imprison you. Absolutely immune. And I know legally, if they have no jurisdiction, they don't have any immunity. Good luck trying to get that through in court. I know we've got Mike and some other people that may say, oh, that they get judges removed all the time, and they sue judges all the time. And, they get stripped of immunity. Yeah, I'm going to have to go ahead and disagree until I see some actual proof with that. Okay? So, if you do have a ticket or you have a complaint or you've got an assessment, something with taxes, it is not easy. Yeah, I certainly can show and have shown a lot of success. That doesn't mean that you're going to be able to replicate it. We've been able to replicate it on 4 continents. Yeah. But that doesn't mean that every single case is going to be successful. And before someone's, unless you are Jerry effing Spence, every single lawyer has lost cases and has lost bad or bigly. Every single lawyer has had a motion denied. Every single litigant who's ever gone to court has had a motion denied. End of discussion. Trying to destroy someone's entire career because a motion was denied by a traffic court judge. Well, you got to take that for what it's worth. Holy crap. Everybody has had a motion denied. Everyone in court has either lost, or if they're lawyers, has lost a case and lost badly for their clients. I don't think that the guys who did the Twinkie defense had their entire career destroyed over that. I don't think they were just barred and could never hire, and nobody would ever hire them again. Johnny Cochran was still hired. So, yeah, motions are filed every day. Motions get denied every day. Motions get denied without explanation. It's not just something that's a feature of my work. That's what judges are so arrogant. They don't think that they have to give grounds for their rulings. And yes, you can read court cases, appellate cases, where it makes appellate judges crazy because they have nothing to go on to try to, because they want to affirm the judgment. And they have to have the judges, they have to have some context in order to determine why the judge did what they did. Now, they don't like to do that. Judges are too damn arrogant. Not all of them, of course. But The ones that tend to be in traffic court? Oh my gosh, the arrogant. They were Supreme Court justice or Chief Justices. They're working in a damn traffic court, the lowest rung of the court system. But their arrogance is only exceeded by their violence. So, I don't usually like to do this part either, but I am going to go and maybe I'll have at least this part in a separate video. There is someone who has trolled my videos for years, and I hadn't even seen a comment, and it came in through the email, and it's just been a while. This is one of the worst comments as far as, trying to attack an argument that I've made in my position. And so this was left in the video where we had another traffic acquittal. It was one that I was just a week or so ago. And let me just read it to you. I'll have it in the video too, so you can follow along. Marc continues to fool himself. I'm not going to fill in the gaps here. It's just, there need be no evidence that a law exists, just citation of the law on the books, which is accepted by judicial notice. Those same laws show what is unlawful, where it is unlawful, and that it applies to all persons in that place. Ball in your court to rebut that. Pretty easy. I've already rebutted this like 1,000 times. You just keep putting the same stupid comment up there without addressing my actual response, which is very typical. So I continue to fool himself. I can't necessarily argue with you there. Hey, maybe I am deluding myself. But we'll look at the evidence to be sure. I think we shouldn't take ourselves too serious. I think we should look to the evidence and accept that and have some humility that what you are saying may not be true. It could be that based on the context that you have, it's logical and based on the evidence, but then you get more context and you might, and I'm not going to discuss the particular philosophy that we've encountered on the show because we don't discuss that anymore. And that's one of the reasons why we don't. So you get more context and your opinion should change. There need be no evidence that a law exists. This is and I hate sounding like this other anarchist. But this is actually accurate here to call this a straw man. No one said, what kind of drugs are you on, this Jehu? I have absolutely never debated or contested on the show or off the existence of the Constitution and the laws. They're written instruments. But for some reason, this is YouTube. What do you expect? For some reason, this and maybe 2 or 3 other people still insist that I'm saying that the laws don't exist. I had a call with the county council a few weeks ago. They said the same thing. They're saying the laws don't exist. Put the ganja down long enough to actually address an argument that I'm actually making, okay? Maybe they're doing something a little bit stronger than ganja. Because I'm going to call it what it is. It's just stupid. I've said it's a written instrument. I said it's a real document. We're not discussing philosophy here. We're talking about a real written instrument that you can see. We want proof that it applies because I'm physically in Arizona and it creates obligations. That's the position. Not that that it's not constitutional or that it doesn't exist. They're gonna, this is why I typically don't respond to YouTube comments because they are so lacking in merit. It doesn't warrant a response. But there again, I did it again. So let's address the rest of this tripe. There need be no evidence that a law exists. Just citation of the law on the books, which is accepted by judicial notice. All right, let's pull this garbage apart. Okay? First of all, it's an accusation by the prosecution. It's a legal claim or legal determination. Claiming that the law applies to me because I'm physically in Arizona. It goes to probable cause. It's an actual element of the charge, which is a trial issue. And that leads into my next point. Trial issues are not subject to judicial notice. Also, when you look at the judicial notice statute or rules, they're very clear. Yes, you've got some exceptions like California, and I'll discuss that in a second. Let me write that down so I don't forget. We're going to get to the California judicial notice. We'll get to that next. Let's not miss that. Judicial notice is not about legal claims, legal accusations. They are for adjudicative facts that are not subject to reasonable dispute. Okay? They are adjudicative facts that are not subject to reasonable dispute. And upon a timely objection, they're not supposed to take judicial notice. They're supposed to have a hearing on the propriety of taking the judicial notice. Is it something that the judge should do? Does the judge have discretion and the proper facts that are not subject to dispute before him? Now, a legal determination by the prosecution is not an adjudicative fact. Now, you could say, well, it's an adjudicative fact that you are physically in Arizona, but that is still an issue for trial, not judicial notice. They have to prove that beyond a reasonable doubt at trial. That's why we've heard it so many times, the lie. Jurisdiction's a trial issue only, that you can't challenge in a pretrial or an arraignment. Not true. Not true. Even if it's against the sacred rules, I've got a mountain of evidence to show that we have raised the issue prior to trial, and we've gotten it dismissed. We've got the motion to dismiss granted for lack of jurisdiction. So the police officer, I'll use this as an example, the police officer's legal determination or legal allegation or claim that the laws apply is not an adjudicative fact. Sorry. So trying to worm your way into the judicial notice, no, you're dead wrong. Wrong. Now, you could, maybe this individual, and you know it's a troll account because the account is empty. You may be saying, well, that might be true everywhere but California, Mark. California, the judge can take judicial notice of the law. Section 455. Jackass. Still no. Because they're taking judicial notice of what the law says. And it cannot be subject to reasonable question. That its veracity is not reasonably questioned. And it is reasonably questioned. So no. I think I rebutted that garbage for like the 100th time. Whom? Okay? Troll of trolls. Ball in your court to rebut. I did. And gotta tell you, I'm not too interested in anything that you have to say about that. So, yeah. Judicial notice is for adjudicative facts. Even if the laws say that they apply to everybody. Does that prove the Constitution applies? The laws don't prove the Constitution applies. Theoretically, the Constitution is supposed to be proof of the laws. So then they're putting it backwards. That's why I've gone through with the call of shames, and they'll say that if I'm physically in California, then the laws apply. What evidence you have to prove that that's true? We've got the Revenue and Taxation Code. Oh, so the code is proof the Constitution applies. Not the other way around? See, the leading question, you want to put that in there. Let them realize how friggin' stupid that is. So, the Revenue and Taxation Code is proof the Constitution applies. but not the other way around. Are you sure? And they'll say, well, no, the Constitution is proof of the code. Yeah! Great! He can be taught. So then we're at square one. We know that the evidence proving the Constitution applies because I'm physically in California is not the Revenue and Taxation Code or any part of the code. So what is it? We'll see what happens. I do need to get to the calls. I've been very patient. I hope if we got any questions on that, I can address that. They say, do you have any evidence they don't apply? Yeah, I always like that one. I love that. Colby Granville tried to pull that crap. We have jurisdiction because we said so, and then it's up to you to prove that we don't. Oh, okay. You just made a proof by assertion. That's completely illogical. You have no evidence. You are the accuser. You're the one making the accusation. You don't have any proof other than you said so. That's not proof. There, I just defeated it. I just showed you that you're wrong. Dead friggin' wrong. Dead wrong. But we'll see what happens. Well, let's get to the calls. It looks like Michigan, but we don't know for sure. Area code 248, you're live on the No State Project. What's your name? Where you calling from?
Hello, Mark. My name's Keegan. I'm from Michigan.
I got that right.
Yeah. No, Metro Detroit area.
I'm sorry to hear that.
Today to ask maybe a few questions. So I travel a lot for work, across the Midwest. And of course, I got a speeding ticket in Kentucky. I don't know if you remember, I emailed you like past week ago about getting motion to dismiss, changing for Kentucky.
Yeah, I got you. I sent you everything.
Right, yeah. So, well, basically, I went in for what I guess they call an arraignment. It was just for a speeding ticket. But yeah, I basically tried to serve them a notice to say, like, to show me that being a beneficiary and the director of my account in a way, or basically saying, show me that the law is applying to me and you have legal and lawful authority as my public servant to bother me at all. Until then, I cannot consent to proceed. But they continued to try to like get me off the point, trying to use like, you know, fear tactics, and like they even said like what I'm asking doesn't make any sense, that I'm not even speaking English, like some crazy stuff like that.
Well, I will jump in, but you know the way you're phrasing it here on the show is a bit awkward. You want to keep it straightforward and say, look. Is it the prosecution's position is that if I'm physically in Tennessee, that your laws apply and give jurisdiction? Do they have any proof that that's true? You know, if they don't understand that, they're either lying or they just don't have the even the intellectual capacity of a high school student, because anybody should be able to that's a dodge. I mean, even the worst of the critics don't say that the question is unintelligible and doesn't make any sense. They just don't think it's a relevant question.
Right. Well, anyway, like, you know, and you were speaking about this earlier, as being very hard to like defend yourself. It is very challenging because you're going in there and you never know what they're going to do, and they yell at you a lot of the time, and it's hard. You got to stay on point. Remember how to, you know, move in a logical fashion, because once they try to get that emotion invoked, then you're moving then you're not moving in logical ways. My main question for you right now is that they basically set me for a trial date, and I objected to that, but you know, I'm still learning the court procedures. So I said I object to that, but I didn't really say like I'm objecting to a trial date, I'm objecting to you putting in I don't even know if they really put in a plea for me. Because once I started getting started with what I was saying and they were like attacking me, I almost shut down a little bit. I couldn't remember if she said I'm entering a plea on your behalf. I just remember her saying, I'm going to set this for a trial date in 2 weeks. And I was like so overwhelmed. But when they set you for a trial date, I mean, what does that mean exactly?
Well, what it means is that the initial appearance, they've determined that they have jurisdiction. and probable cause, there's enough evidence to hold you over for trial. And, I mean, to do that in speeding, this must have been more than 15 miles an hour over the limit. This must have been 20 or more.
Yeah, it wasn't, I wasn't exactly going slow, but anyway, the point is that, I mean, do they have jurisdiction here, or like, and I guess the bigger question I always wanted to ask is like, if they do have jurisdiction, what would they show you? Like, what exactly would it be that we're looking for so that we can say, like, maybe in a conditional acceptance, like, if you do show me this, what is it that they're going to show you?
Well, they can't show evidence of jurisdiction because jurisdiction is based entirely. Sorry, but they can't show you any actual evidence because the jurisdiction is based entirely on the Constitution. All their jurisdiction comes from the Constitutional. That's hence they will be on an unconstitutional, act of the court or the police. So they can't actually give you anything. We're just calling the prosecution on their bluff. They just they bank on, and very successfully, that no one's going to question the foundation of their case. Most people don't. And they've got an army of people out there, called lawyers and shills and trolls that will piss on anybody who dares have the temerity to be a skeptic and actually defend themselves effectively by challenging the foundation. So they couldn't show you anything because they're a criminal organization. I explained at the beginning of the show, because they are literally just men and women forcing strangers to give them money. The pretext for taking the money under threat, duress, and coercion is not relevant to whether there was a crime or not. So, I mean, they're not going to accept those excuses from you. It was, well, I was only taking the money. I wanted to buy my wife a gift. Oh, well, yeah. Or I was only robbing money from this bank because there were so many homeless in my city, and I wanted to help them. They don't give a damn. Criminal, end of discussion. And so we apply the same standard to them. So we're talking about a written instrument. So you look at least 4 factual elements that have to be there for a written instrument to apply and create obligations. And those just aren't there because they're not giving you, they're not there. They're not giving you a choice. Nobody has a choice on whether there's government or not. It's superficial to say that just because you could vote for laws or you can vote for the ruling class, that somehow legitimizes their original act of forcing you to give them money. So I guess I'm rambling. There is no actual evidence. When we go in challenging jurisdiction, we're challenging the prosecution's assertion that the laws apply because we're physically in Tennessee. They don't have any evidence. They'll actually argue with you. Right. They're not going to say to you that they have evidence in their high.
That's exactly what happened. No, I mean, when I did say that, he literally said, "Oh yeah, I have this certified from the state certificate that says I'm an attorney and I'm this and that." And I was like, "Well, I didn't ask for that. I asked that you could prove that this applies to me." And and I knew, and I know this is what you say, is when they get upset, you've struck a chord, because they were not happy. Everyone else moved along breezily. I come in, I question one thing, these people lose their minds.
Yeah. Yeah. See, what I was going to say was, you're not going to get an argument over the facts when you're in court or out with this issue. There are people in and out of court that will actually argue with you. They don't need evidence. This is not in fact, I just went through and talked about, this critic, J. Home. They will argue that no evidence they don't have to prove that. I put a video up with the pictures of and the information for Tiffany Castillo. She actually said that in court. Now, she flip-flopped and said that she has proof, and then she said when called on it, well, I don't need proof. This is not something I'm making up. The only dispute that people have is it effective as a way of defending yourself when you go to court? But to get back to you, they intimidated you to a point, and they met their objective because you couldn't function, you couldn't defend yourself anymore. I would say,
right. And I guess my question is like, I guess with the point I'm at, and like, I need to make a decision because, of course, I'm living in Michigan, so my outpost is, it takes me 6 hours to get there. I tried to handle this administratively. They just won't do that. So I'm saying when I get there, or maybe I submit it through mail too as well. I can still submit the motion for the discovery and the Brady request, and I can still submit the motion for dismissal. And is there like such thing as this submitting a motion to revoke a plea or to strike a plea from the record?
Oh, you can do that. You can do that. You don't have too much time here. Usually, what I like to do when we move to change the judge.
Yeah, my court case is on Monday.
Yeah, you don't have. You don't have the time. I mean, if you're a prosecutor, you can get away with.
They set this for 2 weeks. They set this trial for 2 weeks after the initial thing. Like, that's no time to prepare.
You don't even have You don't even have. That's not even time for the prosecution. Well, there's very little time for the prosecution to even give you discovery if they were even inclined to give it to you. I would still file the motion to dismiss and the discovery request, and I would argue that on Monday. So no, we are not prepared to go to trial.
For continuance?
I'm sorry?
Like motion for continuance, or do I even have to do that? Or would filing the motion for discovery be enough to make them continue it?
No, they're not going to do that. If you do get a continuance, which at this short an hour would be rare, you're not a prosecutor, you don't get that privilege.
No, actually, this is what happened. I called the court clerk, and they said the only way you can get a continuance. I called last week, and they said the only way to get a continuance would be to file a motion with the judge. And then I was like, okay, well, let's do that. She said, the judge doesn't come in until your next court date. So basically, pretty much between my court date and the next one they set, which is the one I have to go to, was the only time to get a motion for continuance. So pretty much no chance of getting continued.
No, you got to prep.
Literally insane.
You got to prep for court. We do the role playing tomorrow, same time as this broadcast. Contact me at Skype at FrankRizzo3. I would still file the motion to dismiss, and when I got the court, I would say we're not ready to proceed with trial. There's a motion to dismiss at play that needs to be addressed.
Oh yeah, I guess this is my last question before I let you go. Is if I file these motions, does that mean that these are pre-trial motions? So I can pre-trial motions. So that means I can say these need to be ruled on before we could proceed to trial.
Yeah,
I can say that?
Right, a motion. Yeah, and if they tried to go forward with that, I would object. I said, objection is a motion to dismiss at play here. And we have a discovery issue. I haven't gotten discovery from the prosecution. How can I effectively defend myself when the prosecution hasn't provided me with the disclosure?
And even if you didn't submit a motion for discovery, should they be giving you that no matter what?
Yes.
As proper procedure?
Yes.
Because they haven't given me anything. I asked for proof. This is the last thing I'm going to say, and I know you probably got other callers, is I asked for proof that these laws apply and that they have legal and lawful, jurisdiction over me. And they just handed me the same citation the cop gave me, a copy of it, by the way, a copy, and said, here, take this. I said, no, that's not proof. That's just a citation, a copy of the citation.
Okay, a problem that I'm noticing now right there, a big problem there is you're saying no and making assertions, and you don't want to do that. When they give you the ticket as if that's proof, you have to say, objection. Is your position that there's evidence on here proving that the Constitution applies to me because I'm physically in Tennessee? Why else are they giving it to you?
Okay.
Now, they can even argue like Jehum, we don't have to prove that. We don't have to prove it. Or they could engage you in it and try to and actually claim that something on and if they do say something on that ticket you have to ask them what exactly on this ticket proves that just because I'm physically in Tennessee, your Constitution applies. All they're going to do is state just your physical location, which you would have to object to. Exactly how does that prove a written instrument called the Constitution apply to me?
Mm-hmm. All right, well, I appreciate you. Now, I just stay on the line, and I can continue with the call.
If you want to listen, you can, if that's the way you're listening, sure.
Yeah, of course.
Okay, well, I appreciate the call.
I appreciate you. Thank you so much. I hope to call back next Wednesday, tell you how it went.
Well, let's do some role-playing tomorrow, okay?
Okay, and how do I do that?
You're going to contact me on Skype at FrankRizzo3. I'll get you the Discord link, and then you can join us on Discord. Okay. And it's the same time as this show.
Okay, wonderful.
4 to 5 Mountain Standard Time, and we'll give you because you need some help.
Yes, sir.
I appreciate the call.
All right, I'll be there. All right, thank you.
You're welcome. Yeah, it's not fun. It is not fun going into court. And it makes things worse when we start making assertions. Because one of the few things I don't think a critic will challenge me on or disagree with me on is no one gives a damn about what your position is on the law when you go to court. They don't care. They don't give it, and if you're defending yourself without a lawyer, they care even less, if that's even possible. So you have to go in knowing that everything they say is a lie and realize that your opinion, my opinion, means nothing to them. It's not going to be persuasive at all. They don't care. They get this upset because they're crooks, they're arrogant, and they've made up their mind that you're guilty before you walked in the door. Because everybody's guilty to them. Well, why would the cop have charged you if you weren't guilty? Everyone is guilty in their eyes. Again, the evidence to support a predetermination is the fact that across all political lines, we get the same stupid excuses from them. And that is because the decision is made in advance, so anything that counters that decision has to be denied. Oh, let's see. We already are going to hold that the laws apply. It's irrefutable. We don't care if that violates due process. And, so anything that goes counter to that, they are going to obviously object to. So one of those is when you put the police officer on the stand and you ask him, did you determine on your own that just because I'm physically in Tennessee that your laws apply and that gave you jurisdiction to do a stop? Good. Yes. Oh, what evidence, what proof did you base that on? What facts did you base that decision on? And of course, the prosecution, we already know what they're going to say. They say it every time. Well, except for once. Objection calls for a legal conclusion a witness may not testify. Now, if you hear something like that next week, Keegan, remember, you didn't ask. We're not asking for a legal conclusion. He already made a legal determination or a legal allegation. He's testified to that on cross. He already testified to that prior on direct, and it's part of the police report and what led to the stop. It's prior statements. So we're not asking for a legal conclusion. We're asking for the facts his determination was based. So they will always sustain that objection. Why? Why would they always do that? Except for one time in Canada with Germain. One time. Why would they do that when any half idiot would realize that the prosecution made an off-point, frivolous objection? Why are they consistently across, again, all political boundaries? You ask the same question, you get the same objection from the prosecutor, whether it's in Canada or Australia or Tennessee. And without question, every single judge has sustained that objection and has never come out and said, the man did not ask for a legal conclusion. I can't sustain that objection. I have to deny it. Overruled. The witness has to answer the question. Because it goes, they don't do that because it goes against the narrative that the laws absolutely, irrefutably apply to you. And cannot be any other way. You cannot challenge it. Again, irrefutable presumptions violate due process. If you cannot, and we'll take the critics at their word, you can't challenge it. If you cannot challenge the foundation of the case, you cannot defend yourself. Due process requires at a minimum notice and opportunity to defend. The hearing has to be meaningful. You have to have an effective cross-examination. And they're telling you point blank. It's irrefutably true. You cannot challenge it. and they'll cheerlead on Facebook and on YouTube. It's only 2 or 3 of them. There's not many. It's. I guess that's just about me. I know people out there, they have family and friends. Oh, don't do that. You're just going to piss off. Well, don't do that. You're just going to piss off the judge. But yes, that very well is a risk, and there's a high risk. I'm not kidding. I've never failed to disclose that. These people, how many times have I said that they have the emotional level of capability and coping skills of a 5-year-old? It's not just the cops. Oh, the cops, it's a given. Oh, come on. But the judges are the same way. The judges are worse because they are in a far more exalted position. They are far higher on the political pecking order, the hierarchy, than a cop. Cop doesn't get to tell the judge what to do. No, the other way around. The judge has absolute immunity and gets to order the cops to do whatever they want. So, keep this in mind if you're new and you're looking to defend yourself against these false charges. While it is very easy to show that they have no evidence, that they contradict themselves, it's grossly unfair. That's easy to do. What's not easy is to go in and remain calm and not get flustered, to know that when they start yelling and screaming, it's because they don't have the proof and they're racking up due process violations. But we do the role playing to kind of hell with that. That's why I recommend going to, and we had someone who posted recently that they did go to a city council. I don't have too many details. I'll have to do that in another video. I'm pretty much out of time. But that will help. But this is part of defending ourselves, is dealing with the judge getting irate. It's an unfortunate part of defending ourselves. You have to take the risk that the judge is going to do, like what Keegan mentioned and what other people are calling the show, what I've seen myself personally. Hey, I've had them call the police to stand right next to me, behind me, stand behind me, ready to arrest me. You still have to defend yourself, but you know it's a part of the mental game. And there was that lawyer that got on. It's a stupid lawyer trick. He's allegedly a multimillionaire who hangs on every word that I say. He came on the show and he pulled this stupid lawyer trick. And I've seen other lawyers do it. I'm not saying it's exclusive to lawyers. It's a very common one for lawyers. And that is to get the person you're talking to upset so that they now lack the rational, thought process. And I fell for it. A pet peeve of mine is being cut off. He knew that was, and he did get to me. I still held my own intellectually, and I still out-argued the guy. But yes, I diminished the impact a bit, somewhat, because I did get upset. I didn't get apoplectic. That's just stupid. But yes, I did get irritated. I got annoyed. And, after 40 minutes of that, your patience, even for a cool-headed Sicilian like myself, it can get to the best of us. So just know going in, this is what they do. If they had the proof, if they had the logic, if they had the reason to back up their argument, they would just give it to you. They wouldn't be arguing and lying and doing all these stupid things. But remember, we object and we ask questions. Objection. If this is irrefutably true, how can I get a fair trial? How can I defend myself? You can't. And that is the end game with them. It's to put on the appearance. Just make it look good. Look, he had his day in court. This is why you'll have cheerleaders for the legal system. You had your day in court, you lost. You had the opportunity, you didn't defend yourself well. Well, the judge denied effective cross-examination. Doesn't that count? See, that's why some people believe just being able to ask questions satisfies due process. Well, you got to question a cop, right? Well, I got to ask some questions. There you go. End of discussion. any discussion. I mean, imagine that all you had to do to satisfy due process, and this is not true, by the way. It's to satisfy due process, you have to have an effective cross-examination. Okay, so there's an examination to what kind of questions you asked that weren't allowed. It's the same thing if voir dire is denied of a jury. Just asking the questions is not enough. You have to be allowed to ask effective questions. And so if you're asking a question going directly to the heart of the prosecution's case, and you're not allowed to ask the cop questions on the facts that he relied on to support his decision on jurisdiction and probable cause, if you can't examine his determination to making probable cause, you're not getting an effective cross. I mean, the idea that you can't ask questions regarding the determination of probable cause. Oh, Madonna me. Are you kidding me? And you're going to try to convince me or some other rational person that's fair? You got to examine the argument instead of being, for and against this stuff and pull it apart. Because the arguments against, like with this J-Home or Hume, just ridiculous. Yeah. Well, hey, I'm glad we got through another show so far without a tech issue, which is very, very nice. I do appreciate everyone tuning in to the big show today. I will be live on Saturday, so if somebody just calls in now and misses, then the Saturday broadcast definitely live. And the role playing is tomorrow, 4 to 5 Mountain Standard Time. Contact me on Skype at Frank Rizzo 3. I want to thank, since now we've got people watching, thank everyone for the continued support of the big show. I'm not going anywhere anytime soon. I'll do the show as long as I can. We have the support. So if you do want to help with that, and it is needed, it is much appreciated, then you can do that at markstevens.net. And this has been the episode 98 of the No State Project, Successes and Train Wrecks, and addressing some really stupid criticism, because dissent is always welcome here on the big show. So, but hey, till the Saturday broadcast, salud.